Welcome, Mr. Farai, Hove, Masaisai. Nice to see you again.
Hi. Good morning, Rennie, and good morning to your listeners. Thank you very much for having me on this morning.
I trust anything that you paid into the system in England, if Miss May has her way, you will not be benefited from
it. my time in England was spent as a student. So.
Well, fortunately for you, that is called almost three-card Monty. It's called a big switch. You pay, you expect, and you get nothing.
Unfortunately.
Fortunately, I have you here for something that's right before us, as I mentioned before. A number of things happen in Trinidad and Tobago. Thank you for taking the time to be with me. Your specialty includes international trade, immigration, and property law. Property tax is something we got to talk with you about because that's part of your specialty. But I do have to ask you this. The appeal court in the area of the injunction that was there, that is the injunction brought to stop folks from volunteering the WRF, which is the valuation form. The appeal court read the same provision that covers the JLC. Okay, I got two issues going on here, so let me just separate it. Let me separate them for a moment. JLC. Let me stay on top of there for a minute because I do want to follow through on the Marcia Air Caesar situation, right? So the Marcia Air Caesar situation, I want to follow through on that. Let me do this.
The JLSC's injunction was pertaining to the appointment of the new judges.
Yeah, the two new judges. That's right, and they sought an injunction to stop the
three judges were appointed previously. That would be Masaisai Caesar, Miss Quinlan Williams, and Mr. I think it's Ramcharan is his name. And then they were going to appoint two, which they eventually did. Two more judges to the High Court bench, and an injunction was filed. And part of the interim relief being sought was to stay the appointment of the two new judges pending the outcome of a substantive claim.
And I thank you for that. I had to get back on the point here because essentially they're saying is that the composition of the JLSC was not legal, was not proper, and they went ahead and said, look, we want to stop this because that JLSC was not properly constituted. What I'm failing to understand is that the appeal court read the same constitutional guideline, the same regulations, and they found that the interpretation was totally against what it really is. I am curious as to why learned judges and those who who carried the injunction forward did not see that it is plainly stated that you can have actions by the JLSC even though there is a vacancy.
Okay, now you see, first and foremost, the judgments of the Court of Appeal have not been published as yet. So in both matters, both the JLSC matter and the property tax matter. So the written reasons, the rationale of the judges has not been made available as yet. What we are going on is really what has been reported by hopefully the news reporters who were in court taking notes at the time of the oral decision.
That is a very important distinction. Thank you.
Right.
Yes.
So in terms of at the High Court level, at the injunctive stage, what the High Court judge would have had to take into consideration is where does the greater risk of injustice lies? Whether it's a greater risk to allow the interim injunction. Now it's an interim injunction, meaning it's not a final injunction. So it would have been an injunction pending a certain thing taking place. All right, and it certainly would not have been past the hearing of the substantive matter. So the substantive issue would have been whether or not the composition of the JLSC was constitutional. The argument against the current, or not the current, but the composition of the JLSC at the time, and even at present, was that first and foremost, they said it's supposed to have 5 members. At the time of the appointment of the judges, there were 4 members. The second point they were arguing was that of the 5 members, so now there are indeed 5 members because the Honorable His Excellency, the President, he did appoint Mr. Ernest Coyle as Senior Counsel as one of the members of the JLSC. He did that last month. So there is a quorum of 5. The secondary argument was that of this 5, there were 2 retired judges, whereas they are saying that there should only be 1. That was the argument in the substantive matter. But in the Court of Appeal, they said, here what? Before a judge is a judge, he is also an attorney. All right, and once a judge retires, he cannot practice as a High Court judge or appeal court judge for a duration of 10 years. So that does not, that argument for them was insofar as retired Justice Stallmeyer sits as a member of the JLSC. All right. The argument did not hold weight any weight in the Court of Appeal because they said here what before judges are judges, they were lawyers. After they were judges, they can't be part of the law fraternity or the judicial fraternity, obviously, for a long period. So, but they can still function. It's not that they're somehow dysfunctional because they are retired judges. And the scenario with Justice Stallmeyer, he was a retired Court of Appeal judge, and he was appointed as a member of the JLSC, and they had an issue with that, given that there was another judge, retired Justice Hamel-Smith, already sitting on the quorum of the of the JLSC. So, so far as those arguments were concerned, the Court of Appeal did not agree with it, and it affected the substantive matter, because the substantive issue was there's no quorum. Well, there was no quorum, but the quorum has been fixed by the president. And the second issue was two retired judges cannot sit at the same time. So the Court of Appeal, in essence, dealt with the injunction, but by dealing with the injunction, they also dealt with the substantive matter. Now, as I said before, the written reasons of the Court of Appeal has not been made public as yet, but it has basically dealt with the entire issue.
So there is no substantive matter to be heard of as far as the reading is concerned.
In the reports, there's obviously an application to the Privy Council. So the matter is not at an end.
But you see, here is my and thank you so much for the clarity there. Next time I must remember to have my coffee early in the morning. Just for a moment there, my brain just went into a whole lot of different gears. Let's stay with where we are here. This area of it, the appeal that they've been granted to take to the Privy Council. All right? They can go on to that. And here is my question. The Chief Justice has gone on, and the President has appointed the judges.
Correct.
Now, if this goes before the appeal court, and they see
the Privy Council,
and they see credence in the argument, or what happens with those who already appointed?
No, well, if the Privy Council, now they have not been given leave to go to the Privy Council as yet, because their application will be based on the judge's reasons, and they have not received the written reasons of the Court of Appeal as yet. But as reported in the papers, they are saying that they will make an application for leave to go to the Privy Council, and I wouldn't doubt it. It's a public interest matter, so it can go all the way. With regards to the Privy Council, if the Privy Council makes a decision that is against, say the Privy Council agrees with the High Court judge in his rationale, because his reasons have been put into writing. So if the Privy Council agrees with Justice C. Prasad's rationale, then they would in effect overrule the Court of Appeal, and you would have to wait until the injunctions will continue until the trial of the substantive matter. Yeah. So it's up to the Privy Council. The ball will be in the Privy Council's court.
What's the wait time on the Privy Council? Anyway, I'll leave that.
Actually, these sort of matters, they actually deal with them quickly.
Okay. 10:37 in the morning. Attorney Farai Hove Masaisai is my guest this morning, staying in that area of the judiciary. There is need for improvement in many areas of our judiciary. I think most folks will agree with that. There's room for improvement in every aspect of life. Many are calling, however, for the removal of the Chief Justice, arguing that the debacle of former Chief Magistrate and former High Court Judge Marcia Caesar has so tarnished the institution that it is time for him to go. How do you weigh in on this?
I could give my personal views, but I don't think it warrants a retirement from the Chief Justice personally. Obviously, it has caused a stir. In terms of the effects on the judiciary, as well as the Law Association weighing in on that sort of thing. But in my personal view, I don't think it warrants a retirement of the Chief Justice. It obviously warrants that the JLSC looks internally in terms of its accounting and its transparency and that sort of thing, and put more more measures in place when recruiting candidates for the judiciary.
That's as it relates to the Chief Justice in the area of the resignation of Judge Masaisai Caesar. That question was. Let us get into one of the areas that we must deal with this morning is the question of property tax. We were chuckling about that situation as it relates to England, but let's deal with it here. Judge Peter Jamada, who spoke for the appellate judges, said this application, this is the injunction that was brought before the court and granted by Judge C. Prasad. This application was flawed upon inception and should not have been entertained. He noted that Devan Maharaj's attorney sought the injunction hours before the state's deadline for response to the pre-action protocol letter was due to expire. Sought action just mere hours before that. Many a layperson saw and commented on this. What do you believe was so ambiguous to have escaped the judge, which is C. Prasad, who granted it in the first place?
Okay, now we have to see what was before Justice C. Prasad. So I've pulled his written judgment, which was given on the 19th of May 2017. All right, and it reads that before the court for its determination is the application for leave to apply for judicial review, as well as a notice of application in which interim relief is sought. So there are two issues. One for an interim injunction and the second one for leave for judicial review. Now, the leave for judicial review was not objected to by the state. So the state's attorneys, they welcomed the challenge in terms of challenging a substantive issue for judicial review. All right. So even in the Court of Appeal, that was not an issue before the Court of Appeal. All right. But the issue was the issue of the injunctions, because the interim injunctions basically stalls the whole process pending the outcome of the substantive matter. And we know in our court system, it tends to sometimes grind a little slow. So obviously, if an injunction is in place pending the outcome of the substantive issue, it can stall the state's intentions. Meaning, the state on the one hand would want to get its house in order prior to implementation of the actual tax. So, for example, they would need to assess the value of properties and so forth. All right, that in itself will take a while. The injunctions were to stop the entire process. So, in the leave application for relief sought, okay, so let's look at the injunctions. On the interim application for relief, all right, the opposition, so Devan Maharaj, he was seeking an interim injunction restraining the commissioner of valuations, whether by himself or through his servants and or agents, from taking any further steps to the implementation and or the enforcement or the decision contained in the press release dated April 19, 2017, that all property owners are now hereby required to complete a valuation report form, the VRF, in accordance with the Valuation Act, Chapter 5803, and return same with supporting documents to the Valuation Division of the Ministry of Finance. All right? So basically, they wanted to stay the entire process. Stop it in its tracks. All right, and that is what they got through it in the High Court. In the Court of Appeal, the Court of Appeal said that the interim injunctions are no more insofar as they are not mandatory. All right, so we have to be careful with that. So
it's not voluntary. Folks can, if they so require, do that, but it's not mandatory. They will not have to pay a penalty if they do not submit it.
Correct. So before, with the press release, this April press release, the Devan Maharaj and his attorneys were saying that based on that press release, it seems that the state is imposing some sanctions which are not lawful, and they are also compelling persons to submit their VRFs, which are they were saying are not lawful as well.
All right. Let me get this right, Attorney Farai, Hove Masaisai. We have the injunction being vacated. In fact, they toss it out. Okay.
Right.
What happens in the area of property tax now? Folks can submit their VRF voluntarily, or if they choose not to without penalty. Got that?
Correct.
The substantive case is going to be heard in September.
Correct.
Now, does that mean that no collection can happen before that
No.
substantive issue, or
No. There's no injunction preventing the state from collecting its tax. All right. So we have to, when we look at these things, we must always bear in mind there's a separation of powers, meaning that the judiciary is the judiciary, it's independent. The executive is independent as well. All right. And the legislature is independent. So the state, the cabinet is basically the executive. And if it is there is a property tax, unless the court says that the property tax is stayed, the implementation of the property tax is stayed, which it did not say.
It did not say.
Because it was not asked to deliberate on that. What the court was asked to deliberate on is whether or not these VRF, the submissions of these VRF forms, which is a process to the eventual implementation of the property tax. Because if you don't have a value of your property, how can they tax you? All right? So the state is basically putting its house in order for the eventual tax. All right? What the state is doing is saying, here what? Say, Rennie, you have a property, just hypothetically speaking. You have a property in St. James. Tell us what you believe your value, your rental value of your property is, and we will tell you what the tax is. All right? So it's allowing you to get involved in the process. Where the alternative to that is Rennie says, I'm not giving you any of my information, even though I believe my property is only the most rent I could get for this thing is $2,000. I'm still not telling you. The state could then send their evaluators, the commissioner evaluators, and they could come with a valuation, and then you might be, the next thing the valuation come back at 4,000. And you are saying, but I think my thing only to, then the state will say, but look, we give you 3 months to bring in your documents and tell us what you, in your opinion, think your property is valued at. Why you didn't take the opportunity? It was in the papers, it was in the court, it was all over the place. It was voluntary. So then you, obviously, in the act, there is provisions for you to object to the state's value that they put on your property. But what the state's argument is that we just want to find out it's like a consult. Their attorneys were basically arguing it's like a consultation.
Yes.
We just asking the public, general public, to tell us what their value is. And then from there, obviously, we will send our evaluators out and they will assess and give a average. So it's not a pinpoint figure. But say if you're living in a community, say a gated community, say for example in Westmoreland, and they think the average value there is $5,000 a month or whatever, that is the average rental, you know, and that's the average rental. The taxable rental is 10% less. So say for example, if say Raymond and Pierre or Farrell and Associates, one of those big valuation firms, come out and they value your property, the state's taxable rental value will be 10% less than the market value. All right? And so I can give an example of it. All right? So for example, if your property, your monthly rental value, that's the market value, is $2,500 or say $2,000, then the annual rent would have been $24,000 because it's 12 months in a year, 8 times 2, that's $24,000. The annual taxable value of your residential property would be $21,600. All right, because it is 10% less. All right, so $21,600 would be 10% less than the $24,000. All right, and it's 3% of that. So 3% of that would be $648 for the entire year.
Right, so we all very clear, and because this is one of the areas that I find disturbing. Even after the injunction was thrown out, the litigant, Mr. Maharaj, said, "I am still going to tell people to be careful. Don't give out your information because by doing that, you put it in the hands of John Public, some who can be hooligans. I think he called it, criminals. But he's saying I didn't like the implication of that because that I find quite disturbing because when the process is understood, which is one of the reasons I asked you to articulate it here this morning, it makes it clear. Here's what happens. You are asked to voluntarily provide something. You voluntarily provide, that's fine. You don't provide it, no penalty. But when it comes time for the state to send out the assessment, They have already done a cabla of the general area, general thing. But you send in something and they have reason to believe that you had modifications and or you are above the average household in that area, then they will send their people in to take a look to get a more accurate assessment.
Correct.
Not dissimilar to T&Tech giving you an average bill if they can get to read your meter. But if they came in, they see something different.
No, but I served as a counselor in the Port of Spain Corporation for 3 years, and the valuations you get from the state are quite less than the valuations you get from private valuations. So, for example, if you're going for a mortgage, the banks will send you by the private valuators, Raymond and Pierre, Farrell and Associates, and those bunch.
Higher value, yes.
And they normally value at market value. The state doesn't value really at market value. They put a valuation there and you'll probably be surprised. But the fact that they're allowing you to get involved in the process, and even if you don't voluntarily submit your information, but you want to query the amount they put on as the value on your property, there is a procedure in the act. Now you have to remember this act has been law on our books since 2009. All right.
That's
so
right.
Since 2009, there has been a property tax. It's just that it was
Suspended.
deferred.
Deferred.
It was, it was never repealed. So, and the implementation date was supposed to be last year, in 2016. But so we in my personal opinion, we have avoided our taxes legitimately because it's through an act of parliament that deferred it. But you can't avoid a property tax forever. It is worldwide, global. Our Caribbean neighbors, my wife is Jamaican, and her parents, they pay their taxes, and they have property in the United States, and they pay their taxes. So when they hear that Trinidad don't have property tax, they're like, wait, it's oil and gas floating y'all, So
yeah, well, I guess it was part of that, but it's no longer flowing that freely. So you've got to pay. All right. The voice you're hearing is that of attorney Farai Hove Masaisai. He's a senior partner in the law firm of Hove and Associates. I want to go into the area of the expectation of John Public. So you hear about this injunction that was filed. You hear that the injunction was dismissed by the appeal court. You hear that the substantive case is to be heard in September. Is it unreasonable for the public to expect the substantive case to be heard by a different judge? And this expectation could be born of, but I think in this case I can be specific, is born of the statements made reportedly coming from the appeal court. I mean, where they just almost dismiss it out of hand because they found there was no basis for this. Is it unreasonable for the public to expect the substantive case to be heard by a different judge? Is my inquiry to you.
I would think it would be unreasonable in the sense that this judge would have had the conduct of the matter from inception. If you pass this caseload, and this is a heavy caseload, to a new judge who is not privy to all the submissions, because remember, these submissions are submissions by senior counsels. All right? There's senior counsel representing the opposition, there's senior counsels representing the Commissioner of Valuations, there's senior counsel representing the Ministry of the Attorney General, because the Ministry of Finance is represented. All right? Any new judge taking up this substantive matter will cause a delay in the matter, because they will want to averse themselves. They will have to get occur with the law around the matter, one. They will have to get occur with the arguments around the matter, two. And then it will cause a delay. It's in public interest that the matter be settled as soon as possible. All right? I think what the public has been alluding to, and is mostly pushed through on the social media front, is they're thinking that this judge is somehow favoring the opposition.
As you raise that question, let me ask you, you see any credence in that line of thinking where folks believe that job shopping is what is going on?
No, well, in my opinion, and I'm telling you from practice, it's no credence in that. There's no credence whatsoever in that. Any practitioner who practices in the civil High Court division and the Civil Appeal Court division, even Privy Council division, knows that this shopping around thing it's not really practical. All right. And a judge, in this particular judge, because I have appeared before him a couple of times.
This is Francis Person.
Yeah, he's just very efficient. He's young. He's probably makes his work his hobby. Because I have gotten decisions, injunctions from him, same kind of speed. Today for tomorrow, that sort of thing. To the extent that when I see Frank C. Prasad as my judge, I know as a fact that I'm going, my client matter is going to run fast.
Just analysis are very clear. You were alluding to what led to this job shopping. One of the areas that led to the judge shopping speculation is because he heard the case, I believe it was 7 o'clock one evening, and delivered a judgment by the next morning. Is that what you're referring to?
Correct. Okay. So in essence, judges are supported by judicial support officers and judicial research officers. Sometimes judicial councils support judges as well. So how they manage their case management functions may differ, but I can tell you for this particular judge, he does it fast. So it's not for practitioners who practice before him, it's not surprising that he would get the more high-profile cases because he turns them over quickly. He delivers his judgments in writing, and when you deliver your judgment in writing, it allows the other side to analyze the rationale of the judge and allows them to appeal on certain grounds. But if you say, for example, it goes before another judge, I'm not calling any names, but it goes before a judge, and they delay. They say, here, it might take me a week to put this in writing because I know it might go upstairs and that sort of thing. The delay in itself, because of the public interest in the matter, it causes a negative effect on the judiciary. And the docket system that operates in the court, it basically assigns, they look, I don't know how it operates, but you see the more pressing matters, the more high-profile matters. For example, I think this same Justice C. Prasad was the judge that dealt with the young gymnast. The young gymnast matter, that was a very Seymour Williams. That was a very high-profile case, and he dealt with that injunction quickly, and he dealt with it fast. There was an application to strike it out for it to go before arbitration before it reached the High Court. I think Senior Counsel Martin Daly was representing Seymour Williams, and he dealt with it and gave his decision in writing.
So you're saying what you're hearing on social media, you're saying is mischief. Like, for instance, if they refer to
rum talk.
If they refer to be careful with that rum talk. The last time somebody used that, they got in trouble.
It literally is. It's not founded. You wouldn't hear a practitioner who practices in the High Court or saying something like that, because we would know from our practice who are the judges who turn over matters really quickly. So if it is the media themselves should do research. They should ask attorneys who appear before Frank C. Prasad how they find his, if it is unexpected of him to give a decision so quickly, which is not the case. He turns over. He's young. I believe when he was appointed as a judge, he was probably the youngest judge, appointed to the High Court, and he does his work promptly.
It is true to say, my guess, by the way, is Farai Masaisai. It is true to say, if I get you clear, is that there may be a possibility here, in your opinion, that hard work and efficiency is being confused with judge shopping by those whose issues come before him.
Correct. And it's not founded. It's not founded in reality.
Let me ask you a question looking in, and one as an attorney, and two, just even looking in as a national of Trinidad and Tobago. Some say the ability to challenge issues in court strengthens our process. Others believe politicizing or abusing court and through injunctions contributes, frivolous injunctions, contributes to the erosion of confidence in our government and our country's institutions. How do you feel about that?
I wouldn't agree to the latter part of that statement. You see, the judiciary, in my opinion, is one of the best institutions we have. All right? The judiciary is there to protect our constitution. So whether it be the opposition, whether it be the government, whether it be an individual on the street that feels they are wronged, the judiciary is there to provide guidance and to provide a level of protection to the Constitution. So in the case of these matters, where else is a better place to ventilate it? Yes, you can ventilate it in Parliament, but if you can also ventilate it in the courts. You see, what the challenge there is a challenge of the Constitution. If allow the process to take its time, and the thing with the process wasn't that long. Even though they got an injunction, the injunction didn't last that long, and even if the Court of Appeal overruled it, there's still the Privy Council decision to come.
So it's never too much. It's never too much going towards the court. You're saying that is the best mediator we have in cases
Correct.
like this.
We had a scenario where the former head of our public service, he went all the way to the Privy
Reginald
Council,
Dumas.
for a landmark decision.
Yes.
And had it not been for him,
He
he did indicate that his lawyers work pro bono and that sort of thing, but it allowed an interpretation of the Constitution that was not previously looked at by any legal luminary. All right, and if they were to stop, say for example, if his attorneys would say, which the High Court shut us down, the Court of Appeal shut us down, if they did not go that one step further to get an interpretation of their views from the Privy Council, they would have stopped, and we would have been none the better. So the jurisprudence is benefits, our legal system benefits, our citizens benefits when matters are brought before the judiciary, because the judicial minds, they are human as well. They can err. Hence the reason there are different layers of courts. If you don't like a High Court judge decision, you can go before 3 members of the Court of Appeal and they will deliberate on it and they will make a decision. If you don't like those 3 members, the Privy Council sits as 5 members of the House of Lords and they deliberate on the issue and they give a decision. And sometimes even if you don't like that, there's the European Courts of Human Rights and these sort of things that our Constitution allows to appeal to. And there are international courts of criminal justice and that sort of thing. So it's always good to have a court system. The judiciary must be strengthened. Any statements that tend to try to say here the use of the judiciary is an attack against the executive should hold no weight in our society. Our society is a democratic society, and anyone who wants to take it to that level and they can afford to take it to that level, they should.
Energetic and a very energetic defense of the judiciary, attorney.
And I hold no brief for the judiciary.
I'm not saying that you do. I just said it was rather spirited. All right. So 2 things to be very clear. One is in the area of the property tax. We have made it clear that as ruled, things are to be submitted voluntarily. However, when the time has come for the assessment, then they will go on the basis of their overview of the area and what they believe you have. If you disagree, you have the chance to appeal that. We are very clear that is the action. Because the injunction has been dismissed does not mean you will not be paying property taxes.
Correct.
It does not mean you will not be paying it. It just means that you do not have to. You're not mandated to submit the valuation form.
The forms. Yeah.
Gotcha. All right. And in the first part, when my brain went on a vacation, which dealt with the Judicial Legal Services Commission, in that area, you say that what has happened here does not rise to the level of the removal or the resignation of the Chief Justice.
It doesn't reach that requirement. Yeah.
The headlines this morning, you could not comment. I don't know because we have not seen all of it, but I know the letter. The letter is reportedly here with Monsieur Air Caesar saying, I was forced to resign. If that is the case, what avenue of redress would she have?
As every other citizen through the court. You see,
That's what I was chuckling at.
Ms. Air Caesar, she is ably represented by Mr.
Ramesh Maharaj.
Maharaj. And if her instructions is indeed as how it is presented in today's Guardian, then she does have a redress. But the redress is not through public derision and public persecution. We should let the system take its course. If she does believe that she has been constructively dismissed, she can attend. Well,
have you ever been to Tobago?
I have.
On a boat?
Well, not recently on the boat.
Well,
because,
when you take the boat, there's a part and they call the bocas.
Yes.
All right, it's troubled waters.
Troubled
I'm going to ask you just to step your foot in there for a moment. If, in fact, she is seeking redress, and would it be for, you think she stands a better chance in the area of chief magistrate being returned to that position, or being returned to what is a high court judge?
I read the article this morning while waiting to come on air.
Yes.
And it's basically, she is saying that she's still a judge. She's saying there's nothing that prevents a judge from hearing magistrate matters.
And she's saying she's still a judge because she's questioning the basis under which she was removed.
Correct. So she's saying that she was constructively dismissed. It was pre-orchestrated, and that would be a matter for the court.
That's a legal term I want to get really clear here. She was constructively
dismissed. Yes. So
she signed a resignation letter, she said, under duress.
Correct.
And you said that is called constructive
dismissal. So there are different types of dismissal. So if say for example judges who are part of a union would be championing that cause. All right. But judges, attorneys, we are not part of unions. So
thank God we got enough bureaucracy to dealing with you all.
So for example, the industrial court deals with unfair dismissal, constructive dismissal, wrongful dismissal. The high court, so the Hall of Justice Civil Division, they will deal with things like constructive dismissal as well as wrongful dismissal.
But let me hold you there for a second. And I mean, we've utilized all our time, but I really want to get this clear. You can sign a letter of resignation. You can sign a letter of resignation, then say, I signed it under duress, which is the claim here. And that is something that prima facie, the court is going to hear that.
They can. Yeah, you have you see, they will obviously have to hear the other side of the story. You know, if it does go the way in court, the court will make a decision on the evidence before it. You know, her evidence based on her letter is that it was a pre-orchestrated dismissal, meaning I just attended a meeting and I was told to resign. I didn't draft that resignation letter. It was presented to me, and
coercion.
Constructive dismissal is
constructive dismissal.
Yes.
Attorney, thank you. You know what that reminded me?
There's always another side of the coin.
Of course, and we will wait to hear that. But it sort of reminds me of prenuptial agreements. You make one, you can go to court and say, and the court will deem it was unconscionable. They say, I know you signed it, but no.
You see, in our jurisdiction with regards to those prenums, once children are involved, they carry very little weight.
That's a different talk show. That's a different talk show. Attorney Farai Masaisai, thank you so much for being here this morning. Thank you so much.
Thank you very much for having me, Rennie.
You have yourself a wonderful day, wonderful Sunday, and we will be getting in touch with you again. There's a lot going to be happening with this judiciary that we will be talking about. Thank you, sir.
Bye-bye.